Good morning. My name is Ierulli, and I am a member of League of Women Voters of Greater Peoria. On behalf of the League and Peoria North Branch Library, we would like to welcome you to our two candidate forums we are hosting here today. The first forum is for our 10th Circuit judges, starting in a minute. And the second one is for Peoria County Board District 6 and 8, which we are planning to start at 11 a.m. We appreciate the audience, all of you attending, coming in today, and the ones that are live watching us from YouTube. The League of Women Voters is a nonpartisan organization. We do not endorse any candidates or political parties. We do take up positions after extensive research. One of the missions of the League is to voter education. We do this through candidate forums. We have been doing forums for many years throughout the country. It is our way for every person in this country to hear directly from the candidates. And we hope today you will walk away with a little bit more information about the candidates running for an office in November. And also maybe consider start voting early. Today, let's start with our forum with our 10th Circuit judges. We have two candidates on the ballot. We have Mr. Frank Ierulli on the left, and on the right, we have Mr. John Spears. Our moderator this morning is Mr. Christopher Kiergaard. Mr. Christopher Kiergaard is going to run through the rules, and we will get started soon. Also, audience, if you have any questions, we have people walking around, so please write your questions on this card. We don't want anybody standing up in the middle and asking the candidates the questions. We want to keep this flowing, so if you write your questions, we'll grab it and then we'll give it to our moderator. Okay, thank you so much. I hope you enjoy the forum today.
All right. Thank you, Anu. I trust everybody can hear me all right, and our candidates will be using microphones. Our primary goal today is to be as fair as possible to the rules the candidates have all agreed upon when they chose to participate, and to be as fair as possible to them. If you note a deviation from our order in answering questions during the forum, please advise me. Our second goal is to ensure that you have all the important information that you need to make an informed vote in this election. Prior to taking the lectern, I observed as the candidates drew cards to determine the order in which they will begin answering today. Mr. Spears will begin first, followed by Judge Ierulli. For the second question, Judge Ierulli will answer first, followed by Mr. Spears, and we will continue to rotate through in that order. In short, the person who answers a question second will then answer the next question first. It ought not need to be said, but for the record, neither of the candidates has seen the questions in advance. And in fact, I only saw the questions 7 minutes ago. So we are all going into this ready to go with a little bit of blindness to it. Some ground rules for those attending today. Please silence your cell phones so we don't have any of those type of interruptions during the course of the forum, which I will remind you is being broadcast live and will be available on the League's YouTube page for viewing after the fact as well. If you must take a call, please step outside of the room to do so in order to permit everyone else remaining in the forum to continue. Other than at the candidate introduction, which we've had, and at the end of the forum, we ask for no applause or audible interruptions. We have a lot to get through as far as where the candidates stand, and we don't want to take away from that time or make it more difficult for anybody in the room to hear the responses. At the end, however, we will offer a round of applause to both candidates and democracy. Each candidate will have 2 minutes for an opening statement, and then 1.5 minutes each to respond to the questions. Each candidate will then have 1 minute to make a closing statement, and we intend to wrap up at approximately 11 o'clock to begin our next forum. We have a timer in front who will wave paddles as the time ticks down to prompt candidates so they know when their time is up. When time elapses, we'll ask you to quickly finish any sentence that you're in the middle of. In the spirit of the race, I thought about bringing a gavel in case it was needed, but decided I could trust both of you to abide by those time limits. We also have question collectors in the room. Question collectors, if you could wave your hand. They will be coming around with note cards for you to ask questions, and we'll be collecting those and we'll pass them up to me during the course of the forum. We encourage you to submit your own questions and try to get to as many as possible, but please remember, any question needs to be able to be directed to both candidates, not just one candidate. All right, let us begin. And Mr. Spears, you have the first opening statement.
Thank you. Test. First of all, thank you everybody for coming out this morning. Thank you to the League of Women Voters for putting this on. It's great for us to have an opportunity here to be heard. I'm a lifelong Peoria resident. I grew up here, went to school here. I graduated from Peoria-Peoria High School. Met my wife, Kelsey. She's out there. We're raising our two children, Henry and Lucy, also here. Peoria is where I've always called home. And like, just by your attendance here, I know that it's something we have in common. We care about Peoria very dearly. A little about my legal background. I began in the Peoria County State's Attorney's Office as an intern under Kevin Lyons. And after law school, I was hired, fortunately, back into that same office by Jerry Brady, who was, at that time, the county's top prosecutor. I also worked under Jody Luce, the current state's attorney, and for the past 3.5 years, I've been a public defender over in Tazewell County. I've been on both sides of the courtroom. I've seen all kinds of cases, from low-level traffic offenses, up first-degree murder, everything in between. I love being a lawyer. The best thing about being an attorney is having this ability through research and communication and sometimes litigation to have a significant impact on the community. And these are issues involving people. Sometimes they're defendants, sometimes they're victims. Everybody needs a chance to be heard, and for very different reasons. My approach is to utilize honesty and respectfulness and diligence in my practice as a lawyer. And that's how you have an impact in the courtroom. As your judge, you can count on the same. Thank you.
All right, Judge Ierulli. Good morning. Please use the microphone, sir.
I feel a little silly in this size of room, not being able to check my voice. However, my name's Frank Ierulli. I'd like to thank Anu and Chris and the League of Women Voters for allowing us to come here today and tell you a little bit about ourselves. I've been enormously fortunate over the last 32 years of practicing law in Peoria County to be both a prosecutor and defense attorney, to be a public prosecutor and do government work, and also be in private practice where I was a shareholder in a large law firm. And then about 8 years ago, our local judges selected me to be an associate judge. That was a competitive process, it was a vetting process. And then about 2 years ago, the Supreme Court went through a similar process and to determine that I was the right fit to be a circuit judge. I'm honored to be here and to be here with you and tell you a little bit about myself. And like any lawyer with a captive audience, I could go on and on and on. But I can tell you this. I've been assigned to some of the most difficult cases as a judge, both in criminal courts and in civil courts. I've been rated by the Illinois State Bar Association as recommended, and my scores for legal ability and meets the requirements of office are in the 90+ range. With that, you can be assured that I've been vetted and tested, and I can do the job, and I would be honored to continue to serve you. Thank you.
All right, that concludes our opening statements. We're going to move on now to the questions. Again, for those of you who have questions, please continue to submit them throughout the process. All right, so we'll begin here, and based on that drawing order, and you've had the opening statement, you've had the second response, we'll take the first question, and we will alternate like that, so the last one who spoke will be the next one to speak. And I would like to hear from both of you. What are the most important qualities you personally believe a judge should possess? Frank?
The most important quality a judge must possess is both experience and the ability to listen to both sides fairly without bias. One of the terrible tragedies we've had over the last 10 or so years is the legitimacy of the court has been attacked. And it's been attacked because some of the decisions people believe are made for solely political reasons. Rightly or wrongly, that is a concern that our community has, and the court's sole basis relies on our community believing that it's legitimate. To do that, the court must not only listen to both sides, but explain why they're making their decisions and allow both sides to be fully heard. That's the only way that our community and the folks, our citizens, will be able to trust us.
All right, John. Thank you.
Everybody in the courtroom needs to walk out of those doors thinking they got a fair shake. No one wants to get railroaded. I've seen it many times in my career, unfortunately, when you have somebody walking out of the courtroom thinking, I didn't get to be heard. Good judge listens. You have to have fairness. It doesn't matter if you were raised on Grandview Drive, Prospect, or Forest Hill, or Cattell Street, or Big Hollow, Richwoods Boulevard. It doesn't matter where you come from. You need to get a fair shake. Everybody needs to be treated equally. So it comes down to understanding and fairness, and you have to be a good listener. You need to know a case front to back. That goes into it. And in practicing as an attorney, I know that very well. You have to be able to master the case. Contrary, I think, to popular belief, a good judge is working long hours. So you got to put in the time. That 30-second thing, that gets me every time. All right, that'll be it.
All right, thank you both. I want to follow up a little bit on your judicial philosophy in relation to what you both just stated here, and I'd like you each to explain to us what your judicial philosophy is on balancing the scales of justice between weighing fairness, empathy, and a strict interpretation of the law. John, this goes to you first.
Yeah, so and I guess to compound the last question, and I don't think either of us are interested in treating anybody, disproportionately. It's about equality. And so when it comes to that, you have to know that, judges and lawyers may view something as, no big deal, or that's nothing in a courtroom. Well, it may be that person's most important issue of their, week or month or even their life. These are very important, significant issues to the public. And so it has to come with a degree of understanding. You have to make sure that you are putting in the time as judge to make sure that everybody that comes in there is heard appropriately. And yeah, I've been a public defender for a while now. I represent some very serious criminals, and some people are just trying to game it. You have that. Maybe they weren't given the same upbringing as somebody else that wouldn't be the same way, but you have to dig in a little bit deeper on those cases. You have to try and ensure that they understand, no, I got treated fairly. Because people are more inclined to receive bad news. And trust me, in courthouses, most of the news is bad news. Most people are inclined to accept that when they realize and recognize, I got a fair shake.
It's fairly straightforward to say that I would ensure both sides are treated fairly. And of course, we're going to do that. As a judge, you take an oath to support both the U.S. Constitution and the Constitution of the state of Illinois. But it's a step further, because you can make sure that people are treated fairly under the law, and they can leave the room feeling like they've been railroaded. Or you can treat them fairly under the law and make sure that they're fully heard, that they have an opportunity to have their say, and then when you make a decision, you explain it. It's been my experience that if you allow someone to be fully heard, if you explain why you're making your decision, then when they leave the room, they may not be happy, but they understand what you've done and why you've done it. And it goes a long way to supporting the legitimacy of the court.
All right. Moving on then, I want to ask both of you, because obviously there have been some substantial changes, particularly on the criminal side of the law in the last several years with the implementation of the Safety Act. That includes changes from money bail to the process we have now, as well as other changes regarding numerous things related to that. While it is no guarantee, and in fact is somewhat unusual for a recently elected or appointed judge to be named to the felony bench quickly, I want to ask both of you, what changes have you seen that have had the greatest impact on the judicial side of the equation, and how do you expect that to have an impact on procedures and decisions you would be asked to implement? Frank?
To me? And John. Well, I think this question is really about the Pretrial Fairness Act. And the simple fact of the matter is this: no one should remain in jail because they're poor. People who need to be in jail should remain in jail, and that's what the Pretrial Fairness Act does. Now, while some folks want to say that this is a terrible disconnect from the way the law was, and it is a substantial change, and people don't like change, but the simple fact of the matter is they've been doing this on the federal side for years and years, and we do this in juvenile court. Juveniles don't pay bond to get out. A judge makes a determination on whether public safety demands that they remain detained and that there's no reasonable alternative. In short, that's what the Pretrial Safety Act does. It ensures that the public remains safe and that people don't remain in custody because they're poor. It's a decision that was a long time in coming, and I think we're better for it.
John?
In addition to the Safety Act, predating that, we also began something in the Supreme Court, which is known as access to justice. And that is essentially identifying vulnerabilities in the community and trying to ensure that fairness is it's really the objective. That's fairness is achieved. So it doesn't matter what your background or what your vulnerability might be. It's an attempt to try and make sure that everybody is treated fairly. That's ongoing. That's been ongoing for quite some time. And then we had bail reform in the Safety Act. And I handle cases in detention court at least once or twice a week. It has its issues, but the ultimate goal, and I know Frank and I agree on this, is fairness. Nobody should be treated any differently. It doesn't matter if you can post bail or not. There are issues with it. Actually, I found a typo not too long ago. There are issues with the statute, but it's new and we're on track. We're trying to make sure that the law applies equally to everybody, no matter what your background is. And so it has been safer. We have much more information on a person before the court when we do these proceedings. It's more hands-on. As public defender, you're required to meet with them ahead of time. So it's progress. And that's the idea, is trying to make sure that everybody's treated equally.
Thank you. I want to spend a quick second and drill in on something else related to court administration. And I'd like to ask for both of your opinions on some of the quote-unquote specialty courts that exist, whether that is drug court or veterans court or some of the others along the mental health court, along those lines. Do you feel those are effective? Are there a need for other specialty courts or changes to the ones that we have? John, and then
Thank you. Absolutely. Doesn't work for everybody. And when it comes, let's take for instance, drug court, because that's probably the one that gets the most resistance from the public. Yes, you have defendants who game it. And for everybody who doesn't know, they're called problem solving courts. These types of courts are supposed to specialize in addressing the need. It's about fixing a problem, identifying and fixing a problem. And so when it comes to drug court in particular, we see a lot of methamphetamine, cocaine, alcoholism. We see these very significant issues that people have a very difficult time kicking. And so the question becomes, all right, well, do we just send them to prison and have them come out, and when they're back, they don't have the tools to address these issues, or do we try to address it hands-on? For every, 10 people that make it, I don't know what the actual stats are, but you do have the 1 or 2 that make it through successfully, and that's positive for our community. It's fixing problems. In mental health court, it seems like mental health court has been growing more and more since problem-solving courts began. There are all kinds of mental health issues in our community that need to be addressed. These are vulnerable people, and they have nowhere else to go. If you lock them in a jail cell because they keep trespassing or doing something property crime related, that's what you usually have. You're still not solving a problem. We don't have Zeller anymore. And so the idea is that we correct these issues so it's not a reoccurring problem for the community at large.
In a word, I believe in problem-solving courts. This is a court that is not right for everybody, but for those problems that can't be addressed through the traditional criminal justice system, it works fabulously. Mental health issues don't fit within the criminal justice system. The criminal justice system is a cookie-cutter approach for every case, and we do that because that's what due process demands, and that's the right way to handle cases to ensure that people are treated fairly. Problem-solving courts address problems that the criminal justice courts are not set up to handle. And a lot of folks in this room have heard me banging the drum about starting a juvenile treatment court. We're in the process with the Mayor's Racial Justice Commission in setting up a juvenile treatment court to address those 40 or 50 offenders that the chief of police tells us over and over are driving crime in our community. We're going to provide resources and access to resources to those folks that need it the most. This will be a very effective way to use our tax dollars in focusing our tax dollars on helping those people that need our help. And I believe it will absolutely make Peoria a better and safer place to live.
all right. I'm going to widen out for a moment again and ask you both something of a philosophical question about what your approach would be on the bench. How would you work in your role to ensure equality for people of all backgrounds in your courtroom? Frank, to make the judges.
Well, the simple fact of the matter is this. My courtroom style is I follow the traditional formalities. Ma'am and sir, to all litigants, I use the title that they want me to use. And the simple fact of the matter is this, that when people come into my courtroom, no matter what their race, no matter what their gender, no matter what their identity, no matter what their religion, no matter what their political beliefs, they're going to be treated the same because they come in as a plaintiff or a defendant, and I address them as such.
John.
Yes, I mean, to suggest anything otherwise is just ridiculous, especially in Peoria. Everybody needs to be treated with respect. It doesn't matter who you are or where you come from or what your background's like. Everybody needs and deserves respect. So I'm very intolerant of that in my own practice as an attorney, as a prosecutor. Fortunately, it rarely comes up, but when it does, completely needs to be cut out. That type of behavior is inappropriate. So yeah, respectful and open, and make sure everybody feels comfortable in the setting. Thank you.
All right. I want to talk for a moment now about the campaign itself, because in Illinois, judges, as is clear by this forum, run for election. In order to run for election, you must campaign, you must raise funds and put out yard signs and everything else. And while there is a separation between any fundraising that a judicial candidate does and the candidate themselves, there may still be perceptions that are created in the community based upon the campaign donors and future litigants in front of you in the courtroom. How do you address that perception, as well as how do you address either undisclosed third-party or non-campaign fund support to you? Starts with you, then.
Ethics have always been an important part of my career as an attorney, and I strive to know what the ethical rules are. It's better to play it safe. I never, one of the big things as a judge is you can't accept money, and you can't even ask for money. You're not allowed to solicit. And so I've ignored that. Anytime anybody's ever tried to approach me with any of that, I said, no, I can't even talk to you about it. It's not something that is okay. There's a significant ethical issue with favors or backdoor things going on. Integrity is paramount in the judicial system. And, I've always tried to maintain that just as an attorney. You bet as a judge, I'll do the same. So something so silly like that, and frankly, I don't have, my account doesn't even have that much to begin with, so it's not really a huge deal. But, that is not something that you want to get tripped up in. So it's a risk that is totally unnecessary, and I'm doing just fine getting out in the community. One of the great things I've been doing is walking door to door, meeting people. Things like that, you don't have to worry about it. You tell people who you are and what you stand for, and if they want to vote for you, great. If not, you throw it. So that's kind of how I've been running my campaign. I stay on the right side of ethics always as an attorney, and I will plan on doing the same moving forward anyhow. Thank you.
The judicial canons, which apply to all judges and judge candidates, are very straightforward and give us a clear guidelines on what we can do and what we can't do. Judges can't solicit for funds or collect funds. And so you have a separate committee structure set up to handle all of that. With regard to how that works, you have a finance chairman and they handle that piece of it. I'm just the candidate.
All right, thank you. Let's pivot back for a moment into the courtroom, and there's been a lot of notice that there are cases, both civil and criminal, that can take multiple years to resolve. What are your thoughts on how to reduce some of the lengthy delays that often stretch cases into multi-year affairs? Right, John?
Well, this is one of those questions that really is very, very broad, and it isn't a 2-minute question. But to make it a 2-minute answer, what I'll tell you is this. Our criminal court cases go very, very quickly, generally. If they're murder cases or more severe or complex cases, they can stretch on. And there are very rigid timelines that have to be kept. Civil court cases are much, much different. I'm currently in L court, which in Peoria County is primarily medical malpractice cases and large commercial disputes. So those cases take years. And there's really no way to accelerate them, particularly since we've had COVID, which caused a 3-year hiatus in moving our cases forward. I did a jury trial on a medical malpractice case just this week that was from 2017. And while we're moving as quickly as we can to get those done, there's only so much room in the hose to push them through. No attorney wants to be double or triple booked to have experts flying in from all over the country only to find out on Monday morning another case is going. We're doing the best we can. Could we do better? Certainly in criminal court, I think we can move cases more quickly, but in civil court, it's going to move at the pace it's going to move at.
Yeah.
serious cases do tend to take time, and no attorney really wants to stick their neck out on the line and say, I'm going to move this quicker, because then you're facing maybe an ARDC complaint or ineffective assistance. The one thing that I have tried to do through my career is make it quicker for folks who are appearing in the day-to-day. So if you go for a traffic ticket, you're not sitting around for 3 hours waiting to get your $120 paid or whatever it is. When I was working in Peoria, my boss at the time, Jerry Grady, he assigned me to help implement into the Odyssey system, which, if you recall, Peoria County purchased some years ago, forms to help expedite it. It's a great system that's in Circuit Clerk's office and court-wide. And I developed all these forms to try and make it quicker and streamlined so people aren't waiting around, and you can kind of get through the process quicker. That has driven me crazy since day one. I don't like seeing somebody sitting and waiting in a courtroom all day just because we're going to continue the case, or whatever the case may be. So any chance we get to make it quicker in the day-to-day, I've always jumped all over that. Those forms, by the way, they're still being utilized to this day. So I hope to get back in there and make it even faster and make it more economical, because efficiency is very important in the courtroom. We've got the technology now. We need to keep compounding it to make it work better for us.
All right. Let's dive a little bit into politics, if we can, because you each carry a letter after your name, and you are running on a party name as well as an individual, because that is what is required in Illinois. There's an argument that politics should not be a part of the judicial system, and yet we see in different levels of the judiciary, particularly at the federal and state Supreme Courts, that often there is a political alignment in the decisions. In what way will each of you separate out the partisan identity you are running with now from the administration of justice if you are to be elected? John?
Yeah, I get that all the time. Why is this partisan? I don't know. It might be too complicated to do this any other way. But one of the things that I make very well known is, when I become a judge, I'm not going to check party backgrounds at the courtroom door. I mean, no judge does that. It doesn't have anything to do. You go on the facts of the case and you apply the law. That's what the duty of the job is. And so, yeah, you do. You shed your party's essentially kind of ideals when you step foot into a courtroom as a judge, because you are required to follow the law, whether you like it or not. That's what you're forced to do. We both are aware of instances when that hasn't occurred. So it's not something that any sharp judge is willing to stick their neck out for. So.
Right.
Do you need to speak with Chris? Politics has no impact on my decision-making. The simple fact of the matter is this: I simply apply the law to the facts, and that's it.
All right. We are nearing the conclusion of our time here, so I'm going to ask each of you to be prepared for your closing statement here in a moment. And Frank, I'll start with you.
Once again, thank you for coming here today and giving us your time. We know your time is precious, but judge races are low information races. They simply are. They're at the bottom of the ballot, and folks don't know much about us. But I hope today I've answered some of your questions and perhaps allayed some of your fears. In short, I've been a lawyer for 32 years and a judge for almost the last 8. I've been selected both by our local judges to be an associate judge, and then later by the Supreme Court to be your circuit judge. And I would be honored to have your support and your vote. Thank you.
John.
Again, thank you everybody for coming out. Hopefully my children weren't too distracting for you. I know they're not in the room right now, but honestly, I wouldn't be here Had it not been for the support of my family, so I want to make sure I mention my family and close friends in the committee that have been very supportive all along. You know, being in this practice it's great, and I can't help but notice, but Frank and I, we had some similar answers this morning. You know, the mark of a strong judiciary is 2 qualified candidates, and so, you know, he and I, we don't have any real significant issues against one another. When you go into that voting booth, either if it's November or in September, you know, I would love to have a chance to talk to you. Keep me in mind, and from what you heard today, you know, you have some slight variations, I'm sure, but I'll be around after this is over. I'd love to talk to you. In my practice as an attorney, I've always tried to maintain respect and tried to maintain honesty. Those are things, open-mindedness. You know, I'm not going to be forgetful of those things. Who you have right here before you today is who you're going to get. I'm so proud to be here, and I appreciate your time. And keep me in mind when you go vote. Thank you.
All right, and as a reminder, early voting begins September 24th, and the election is on November 5th. Let's give both candidates a round of applause, and let's go back. And we will